we are going to do a gear shift, and Seth and Ioana are going to walk us through the when, how the pandemic and the other conditions of our climate have impacted when we work in our new world of work. Over to you, Seth and Ioana.
Thank you, Laura. So in terms of when we work and the changes brought about by COVID has introduced a number of new considerations that relate to rights employees have while working and when they're not working. So whether in the physical or remote workplace, there are a few key areas that should be on employers' radars in this regard. First is vacation entitlements. Due to travel and mobility restrictions placed on Canadian workers due to COVID, many have been reluctant to take their vacation over the past year. Employers must ensure, though, that employees are taking their statutory minimum vacation entitlements each year. This is a legal requirement mandated by the applicable employment legislation in your jurisdiction. And if employees aren't taking their minimum vacation time, that's actually a breach of those employment standards laws. If employers do have a policy of paying vacation when it's taken, as opposed to accruing on every paycheck that an employee receives, employers who fail to ensure that mandatory vacation time is taken could also be liable for unpaid vacation amounts that could accrue over time where employers or employees are not taking their vacation. Also, employers who fail to track and stay on top of employee vacations may find that employees have accumulated excessively large vacation banks where the employer's vacation policy permits carryover from year to year. This will eventually need to be paid out, or the employer will need to deal with how the employee will be taking that substantial vacation entitlement over future years. That could create another practical issue for employers. Practically, employers are well advised to stay on top of vacation entitlements at this time for this reason. Next topic is sick leave entitlements, another very relevant issue at this time. At this time, it's more important than ever that employers and employees are on the same page about sick time, understanding what entitlements employees can make use of when they're unable to work for reasons related to COVID, vaccinations, or side effects that an employee experiences because of a vaccination. Employers must familiarize themselves with government COVID-related sick leave entitlements within their province and jurisdiction. For example, in Saskatchewan, Alberta, British Columbia, and most recently in Ontario and Nova Scotia, provincial governments have mandated paid sick leave entitlements. The specifics of these paid leave entitlements vary, sometimes very much, across provinces. So employers need to familiarize themselves with the entitlements in terms of sick leave based on every jurisdiction that they're operating within. Next is employment standards. So one of the most common areas employers can run into problems is hours of work and overtime. I can tell you in the remote work context, tracking work hours, overtime, and ensuring that employees are taking sufficient breaks and hours between shifts is obviously more challenging than it is in the physical workplace and presents a new challenge for employers. Unfortunately, this is also, coming from experience, one of the areas where employers can accumulate substantial liability in terms of unpaid wages to employees for hours that are worked that employers never even knew about. We've seen multiple cases in the recent past where outgoing employees have hit employers with claims for thousands, sometimes tens of thousands of dollars in unpaid wage and overtime claims, in addition to claims for their termination entitlements when they're on their way out. In some cases, this could effectively double the amount that an employee is owed upon dismissal. In the event that employers fail to track and manage work hours, they could be subject to not only penalties under employment standards legislation, but these substantial claims for unpaid wages and overtime pay. So if employers are considering permanent staff reductions, this should be something that's on their radar. Is there a potential that employees have been working hours that weren't accounted for and potentially overtime hours? Because if an employee seeks legal counsel and turns around and threatens a claim against the company, that's likely going to be something that they're going to raise as an entitlement and could potentially double the amounts that they're claiming from the employer. Next thing I'd like to talk about is the right to disconnect, a new issue that should be on employers' radars, though. So Canada, the federal government, is currently exploring the possibility of introducing right to disconnect legislation. So right to disconnect generally refers to providing the right to employees to disengage totally from all work-related activities outside of working hours. Federally regulated employees soon could be provided with legally protected periods in which employees must be allowed to disengage from all work activities in total. So think remote work arrangements, think employees who have cell phones, who are checking their work emails on a constant basis. This would no longer be allowed. Interference from employers during these disconnected periods, as I'll call them, could result in penalties to employers. While no province has yet discussed implementing such right to disconnect legislation, if the federal government does implement right to disconnect rules, certain provinces may follow suit. So as such, any employers who are considering moving to remote work, especially in the long term, should have right to disconnect and these potential rules coming down the pike on their radar. The last point I'd like to touch on with you is flexible working arrangements, obviously very relevant in the context of COVID. Employers are receiving more requests than ever for flexible working arrangements from employees who don't want to work standard hours or maybe don't want to work in the office and want to work at home. However, over the last year, we've seen employees make requests to work from home, but also requests to remain in the office throughout the pandemic. These requests can come in many forms. It really depends on the concerns of the particular employee and the nature of the particular workplace. Employers are under no strict legal obligation to provide flexible working arrangements unless required based on a protected human rights ground. Think family status, think medical concerns. Where requests for remote work are related to a protected human rights ground, such as family status or medical concerns, these requests must be handled in good faith, and the employee's requests must be accommodated where possible to do so short of undue hardship. So while employers are under no strict legal obligation to provide flexible working arrangements, whether that be flexible hours, flexible location requirements, a recent study does indicate that 80% of Canadian workers feel that flexibility in work location and flexibility in work hours would allow them to better take care of their own mental health and reduce stresses related to work. So accordingly, where possible, employers may want to make use of flexible work arrangements where it's possible to do so, as these practices could likely result in increased employee morale as well as employee productivity. So at this point, that concludes my segment, but I'll kick it back over to Ioana to discuss takeaways and best practices for employers related to when we work.
Thank you, Seth, for those comprehensive considerations about when we're now working. So we've taken all of the considerations you've spoken about and we've summed them up in 4 main key takeaways for our audience today. So the first one is record keeping. This is a simple yet often overlooked obligation by employers. With proper record keeping, employers can preempt overtime claims. And if a surprise overtime claim is brought, as Seth, you mentioned, we see in our practice, then they can be ready to respond with evidence because they will have the records to back up the hours of work an employee has been working. One part of proper record keeping is having an actual system in which employees input start and end times along with their break times. But employers can also record break times on calendars and reinforce employees taking their breaks, which over a week would add up to several hours employees are not working and would prevent some overtime claims as well as burnout. Number 2, implement a comprehensive work from home policy and enforce it. This is another simple solution for employers to tick off a number of the boxes Seth walked us through. Some of the key things a work from home policy should include are expectations for employee availability and typical hours of work and where flexibility may be required. And to prevent burnout and preempt accommodation requests, specify if and when employees are actually required to keep their devices on, or if they should turn them off and not check them after a certain hour unless there's truly an urgent request that comes in after hours. A work from home policy should also include guidelines on how employees are required to track their hours of work. Guidelines about how overtime should be requested and how it will be approved should also be included. This will help minimize surprise overtime claims. And another consideration, another key aspect of a work from home policy is other key issues such as expectations for productivity and engagement when employees are working from home. This will help reinforce the typical workday parameters when working from home. The third key takeaway is implementing and reinforcing vacation and leave policies. Vacation policies will help manage employees building large vacation banks and expectations around when they must take at least part of their vacation each year. Ensure people managers are not making side deals with employees not wishing to take vacation, but reinforcing the importance of vacation for rest and not only for travel. Consistency will be key with all employees. Vacation policies should also clearly specify by when employees are required to take their vacation each year and what amount, if any, they are allowed to carry forward into the next vacation entitlement year, and even how long they may have to use that carried forward vacation. Another key aspect is seeking legal advice when attempting to eliminate vacation banks for employees, because there could be important legal considerations depending on the jurisdiction. We actually, in our practice, have recently helped an employer operating in multiple provinces determine its obligations to employees when it comes to vacation banks and how to deal with them in a legally compliant way. The vacation banks for all employees were likely in the hundreds of thousands of dollars, so the employer really needed to prevent this continued accumulation from a business perspective, particularly as employees became reluctant to take vacation during the pandemic. We helped the client reset ground rules for taking vacation with their employees while also minimizing constructive dismissal exposures and potential claims for unpaid wages. Further, leave or sick policies will also help employees know what options they have available when they need them. Employers should communicate whether employees can use vacation time or personal days when they're sick. Employers should also communicate government leaves so employees are aware of them and take them as needed. And the fourth key takeaway is flexibility. While having robust policies is a key thing for employers, ensuring people managers know when they should be flexible with employee requests is equally important. Employers and managers need to be aware when requests for different start or end times may actually be grounded in a disability or caregiving need, and then make sensitive inquiries to meet their procedural duty to accommodate with reasonable measures while still meeting their business needs. When employers don't have a legal obligation to be flexible, but may decide to be flexible more from a morale standpoint, they should ensure they are offering the same options to all employees out of a sense of fairness. This will prevent employees feeling like others receive preferential treatment, which can potentially escalate into legal issues.